Hello, all. So, we are finally reached to our last topic, Negotiable Instrument Act. Uh, Give me 2 minutes. Before we start our Negotiable Instrument Act, can anybody tell me that they have a little bit any idea about what is negotiable instrument? So, why we are studying Negotiable Instrument Act, or why do we need a negotiable instrument? I hope uh, some point of time this kind of question would have popped in your brain, right? कि हम whenever we are going to study any act, we should no question ourselves why we are studying it, what exactly the word, any whatever the heading of that act, you should understand what it exactly mean, literal meaning of it, or why we are studying that act itself. So why do you think we need a negotiable instrument? नेगोशिएबल इंस्ट्रूमेंट किस चीज के लिए यूज होता है? ट्रेड एंड कॉमर्स के लिए. So in a general parlance or in a layman language also we can say that negotiable instrument is used for to facilitate trade and commerce, right? And why we need a negotiable instrument? Because it is difficult to carry cash. Suppose if you need no if you're going to any place and you need a 10 crore rupees, so instead of carrying the entire in a physical format, you can no use a negotiable instrument for that transaction. Or if you want to pay it in a future date, you can use a negotiable instrument, right? So why a negotiable instrument act came? It is that in traditional time there is no ni, but still negotiable instrument are used, like your hundi. So at that time there is no ni act, right? So why ni act is required? NI Act was required because in order to give a legal sanctity to this transaction, if there is no NI Act, then though there is a transaction happening or negotiable instruments are getting used, but that instrument is not having a legal sanctity, right? So, what do you mean by negotiable? And what do you mean by instrument? नेगोशिएबल का मतलब क्या होगा आपके हिसाब से? लेमन लैंग्वेज में अगर हम समझना चाहें तो इट इज जस्ट अ ट्रांसफरेबल. एंड इंस्ट्रूमेंट मीन्स एनी स्पेशलाइज्ड डॉक्यूमेंट. सो आप लोगों ने इंडियन एविडेंस एक्ट पढ़ा होगा, डॉक्यूमेंट का डिफिनेशन दिया हुआ है. बट what is the difference between document versus instrument? What definition is given in Indian Evidence Act for document? The basic purpose for document is for recording certain thing, right? But for instrument, if I say, it is an specialized document which gives you certain right and liabilities. That's why when we see a check being a negotiable instrument, it's give you a right. Like the person who is having the check uh, has right to receive that amount, and the person who draws that has liability to give that amount, right? So instrument is giving certain right and liabilities. So it is a specialized document, but we cannot call it as a document, but because it is not only for recording certain matter, right? And what is negotiable? It's in a general parlance, it is just a transferable. So any instrument which is transferable is called as negotiable instrument. But what being a negotiable instrument under Negotiable Instrument Act, we have to see your preamble plus your section 13. So what preamble says? It is to define and amend the law relating to promissory notes, bill of exchange, and check. So, but why only these three? There can be many other instruments which can be a transferable and can facilitate your trade and commerce. So why only three is mentioned? What do you think? Hundi is a negotiable instrument? What, today all of you are mute? You must have read it, I think. Yes, Ananya. So you are saying that Hundi is not a negotiable instrument, right? Okay. Anybody else has different answer? See, there is two things. One is negotiable instrument, and another is negotiable instrument. Uh, Instrument Act governing negotiable instruments. So, if we see that NI Act uh, only these three instruments on which NI Act is applicable: your promissory note, bill of exchange, and check. On this, your NI Act 1881 applies. But that doesn't mean that your hundi is not a negotiable instrument. Yes, Susri, you are correct. So it is mentioned in the act, but how I will let you know. But for a time being, let us understand that NI Act is saying that NI Act is applying only on the promissory note, bill of exchange, and check. Okay, but other negotiable instrument, on that your NI Act is not applicable. Then what is applicable? Your mercantile custom and your trade usage. Okay, so if any local place or if any mercantile custom says that okay, these are in these instruments are getting being used, like your bearer debenture, your railway receipts, your hundi, all these are what? These are NIA and negotiable instrument only. But these are not your instrument which are regulated under NI Act. I think bill of lading is also one example. Wait a minute. So if anybody can tell me what all negotiable instrument I have mentioned, which are not regulated by NI Act, by NI Act. Hundi, your bearer debenture, railway receipts, and bill of lading are some example which are negotiable instrument, but not your this. Okay, just a minute. So these are the recent developments wherein few amendments came in 2002, 2015, and 2018. You have to go through that what exactly what are the amendments came. Basically 2018 and your chapter 17. These are important. Okay, so when we are discussing about what is negotiable instrument, you have to see the section 13. Section 13 says that a negotiable instrument means a promissory note, bill of exchange, or a check payable either to order or to bearer. Okay, so uh, whenever we are saying about negotiable instrument, it is either to be it is either transferable to order or to a bearer. So when we are saying the transferable can be possible by two method. One is your delivery and another is your endorsement and delivery. So what do you mean by delivery? Do you think delivery is very much important? And what do you understand by either to order or either to borrow to bearer? See, whenever we draw a negotiable instrument, okay, but if you're not delivering it, then it is not a transferable instrument, right? So in order to make any instrument negotiable, it has to be delivered. So and but this transferability can be possible by two method. One is delivery, wherein you are either giving it to a specific person, specified person, or endorsement and delivery, wherein you are allowing it that it can be endorsed. Endorsed means that you are saying that suppose if I say that this instrument is paid to Mr. B. Okay, but if I say Mr. B, then Mr. B can also transfer this instrument to somebody else also, whom he has to make the payment. So then it is an endorsement. But only delivery, if I'm saying, that is you are not there is no right of endorsement. Okay, so here we have to understand that either to order or to a bearer. So when I say that no, if I promise to pay you 1,000 rupees, suppose A is promising to pay Mr. B 1,000 rupees. Okay, so Mr. B has either can receive that amount from Mr. A or can endorse it to C. Suppose he has some payable to C, then he can endorse it. Okay, but if you have seen a check, okay, if you give a self check, then what it is a bearer check, right? So it is a bearer instrument, and bearer instrument means anybody who is holding that instrument can receive that amount from the bank. So bearer means any person who is holding that instrument can receive the money. But but if the amount, if that instrument is having a specified person name mentioned, then either that person can receive that amount, or he can either endorse it. Okay, so so what do you mean by endorsement then, according to this understanding? Do you think endorsement starts with E or endorsement start with I? Is there any difference between endorsement starts with E and endorsement, the word endorsement start with I? Because here in the act, if you have seen, the word mentioned is a word start with I. I give you a task. You need to find out what is the difference between endorsement start with I and endorsement start with E. Okay, and I hope it is clear what do you mean by order and what do you mean by bearer. When in instrument it is specifically mentioned as payable on order, then it is an order instrument. Or if it is mentioned a name of specified person, then it is an instrument payable on order. Okay, or to a person, specified person, because if only you mention a specified person, that means the specified person has right, also has right to endorse that instrument. But if there is no specified person name is mentioned, then it is a bearer instrument. Okay, so your definition says that NI is payable to order if it is expressed to be so payable, and if it is expressed to be payable to a specified person, does not contain certain words prohibiting its transfer, then it is endorsement and delivery. So why we are saying endorsement and delivery? Why not only endorsement? Why this delivery is very much important? Because suppose if you endorse it, but you keep it in your drawer itself, then also it is not a negotiable instrument. In order to have no transferable, it has to be given it to that person. That's why it is mentioned endorsement and delivery. And if suppose in case of endorsement also, if the in case of endorsement also, if the last person name is not mentioned, suppose you have given, if that person, the holder of that instrument, has endorsed it to a five different person, so every five different person, every four person has endorsed it, and the fourth person just signed it on on last page or on the front page, say, just signed it but has not mentioned the name. If the name is not mentioned, that means it is endorsement in blank. And whoever is holding that endorsement, that instrument, wherein the person name is not mentioned, but the last person who has no whose name was mentioned earlier has signed it, that means that instrument becomes bearer instrument. See certain example. Your a check made payable to a specified person, and that check is endorsed by signing on the back of the check by that specified person. Okay, and whose name, suppose Mr. A has issued a check to Mr. B. Okay, and Mr. B has signed it on the back of the check and mentioned C. Now C can also further sign it and mention any person D. So this is how the endorsement happens. Okay, so by this, what do you understand, that endorsement can be possible to multiple people. And how the check cannot be endorsed further? Suppose in case of account pay check, so if Mr. A is giving a check to Mr. B, and he has mentioned on the front account pay, or has drawn two lines. Okay, so what that means, that it is an account pay check, and now only Mr. B will receive that amount. It will not be further endorsed. Okay, so now, can anybody tell me what do you mean by endorsement? What do you understand by endorsement now? Open section 15 of NI Act. Yes, Susri. The definition is there in the section 15 of NI Act. Okay, let me bring it for you. Yes, this is. When the maker or holder of a negotiable instrument signs the same, otherwise than as such, maker for the purpose of negotiation, on the back or face thereof, or on a slip of paper annexed thereto, also signs for the same purpose a stamped paper intended to be completed as a negotiable instrument, he is said to endorse the same and is called the endorser. Okay, so from this definition we understand there is two party. Okay, one is your endorser and another is your endorsee. And who is endorser? Endorser may be your maker or a holder of a negotiable instrument. And what that maker or holder of a negotiable instrument is doing for the purpose of endorsement, what they are doing, signing the same on the back or face thereof, or on a slip of paper, or sign for same purpose as stamp paper. So from this we understand that endorsement is for the purpose of transfer. And why endorsement is there? It is because whoever is having that instrument is going to get the money from maker of the instrument, right? And how that endorsement is happening, that it is in the definition itself, it says that by the maker or a holder of the instrument is signing the same, uh, either on the face of the instrument, like on the face of the instrument, or on the back side, or if the back side is also full, they if the holder or maker want to endorse it further, then he or she can attach one slip, any paper, blank paper, and that blank paper is called as your elongi. I think elongi or elongi, you just see the pronunciation. And instead of attaching that slip, they can also attach a stamp paper. Okay, and there the same process can start. It There is no such limit, there is no number, xyz number is not mentioned in the act, that this much endorsement is only possible. You can endorse as much, as many time as you want. That is the that can be a possible scenario. Okay, so that's how the endorsement is done. Now, do you think endorsement needed in bearer instrument? You have understood what is bearer instrument. Now, tell me, do you think endorsement needed in bearer instrument? In your instrument is transferable in a two manner, right? One is your by mere delivery, and another is your endorsement and delivery. Now you have to tell me whether endorsement needed in bearer instrument. Which kind of instrument? Yes, Suvendu. So tell me again, which kind of instrument is transferred just by mere delivery? You simply need to just deliver it in order to transfer the instrument, because there is two kind of instrument. One is your bearer instrument, and another is your wherein the specified person name is mentioned, right? So in case of bearer instrument, you need not require to endorse it. Any person, just by handing it over to any person. Like today, if I want to, uh, s- deliver that instrument to Suvendu or to Ananya or to anybody else, I simply just hand it over. Suvendu can hand it over to Ananya, Ananya can hand it over to Sanna or to XYZ. Like that can possibility, right? So you need not require to endorse. Endorsement is the whole purpose of endorsement is for transferability. And if by just delivering, if certain instrument is just transferred, then you need not require to endorse it, right? And the bearer instrument, there is no such specified person name is there. So any person who is holding that instrument can just by delivery transfer that instrument. So there is no requirement of endorsement in case of bearer instrument. But do you think endorsement needed in our order instrument? Yes, definitely yes. And what do you mean by order instrument? By just we understood that in any instrument, if we have mentioned that this amount is going to be received by X, then we are or on his order to anybody else, right? So that is called your order instrument. So that person whose name is mentioned in that instrument as having a right to receive that amount, that person can endorse it to somebody else, his right to receive that amount. Okay. So who can endorse? Obviously, if the first endorsement will be done by your payee, and the subsequent endorsement is possible by whoever is holding that instrument. Means the payee has endorsed to X, then X is the holder of the instrument. Now holder can further endorse it to anybody else, right? Is it why it is written that when the maker or holder of a negotiable instrument sign the same? Okay, so why the maker? How the maker is going to endorse that instrument? because maker is only is going to give it to pay when the whoever is making that instrument is going to no give it to whom, to a pay. So pay is the first person who is going to endorse. Then how the maker can be a endorser? Think of a scenario wherein a holder wherein a maker can endorse the instrument, because initially always a payee can endorse the instrument, not a maker. If I being a maker, I have to pay say Mr. A, then I, when I am issuing that negotiable instrument to make for that xyz amount and giving it to uh, x, right? So I being a maker, I have given it to x, that I owe you this amount and I will pay you on this particular date, whatever. Okay. Now this instrument, through this instrument, that Mr. X has right to receive money from me, and Mr. X, if he owes some money to somebody else, he can endorse it to that person. But how I, being a maker, can endorse that instrument? So give me a scenario, Subhendu, when a maker become a holder. You have mentioned, right, power of holder, as in the power of holder, maker can. Please switch on the mic and you can say it so that everybody can understand and discuss on that. You have mentioned that A draws promissory note in favor of B. Yes, so B becoming a payee and A becoming a maker. Then how A becoming a holder of the instrument? B is holding that instrument, right? Think a scenario wherein A has to make a payment to B, B has to make a payment to C, and this is how the chain continue. And simultaneously, and in that scenario, suppose this transaction goes like this: C, D, E, F, and B, F has to make a payment to A, and F has given that promissory note to A. Now A has two status: he is maker as well as the holder of the instrument. Now A need not require to make payment to anybody, because from this chain he received that instrument, and now he is maker as well as a holder. Now being a holder, he has right to endorse it further. I hope it clears the doubt, right? So we have understood what who is endorser and who is endorsee. Endorser is always your pay. Kinds of endorsement. So for understanding your kinds of endorsement, you have to go through these three sections: section 16, section 50, section 56, and 52. It talks about different types of endorsement. Okay, section 16 says that if the endorser signs his name only, the endorsement is said to be in blank. And if he adds a direction to pay the amount mentioned in the instrument to or to the order of a specified person, the endorsement is said to be in full and the person so specified. So it talks, section 16 says about two types of endorsement. One is your a blank endorsement, another is your full endorsement. So blank endorsement means, we have just discussed that a person is signing on the back side of the on the back side of the instrument or on the face of the instrument, and he is not mentioning the name of the person to whom this instrument has to be paid, right? The money carrying the instrument has to be paid. In that case, that instrument becomes a bearer instrument. But if if that person give a direction to pay the amount to the order of a specified person. See, either he mention a specified person name, or he can also say that specified person or to order of that specified person. Both is possible. Okay. And if he only mention the specified person name, then also that specified person has right to endorse it further. Or if he mention it specified person or to the order of that specified person, then also that instrument is further endorsed. Okay. So when the name is mentioned, then it is called as full endorsement, because that person has right to no endorse it first further, whose name is mentioned in the instrument. Section 50. Okay. So before we go to section 50, section 49. So we have already understand how the conversion of state endorsement in blank into endorsement in full is possibility. So if I think this answer can be provided by you, anybody of you, how this blank endorsement is converted into full endorsement. If I say that A has endorsed instrument to B, B has endorsed it to C. Now C has signed it and has not mentioned any person name. Now what it becomes? It is a blank endorsement, right? Now this C has handed it over this instrument to D. Now tell me how this blank instrument can be converted into a full endorsement. Suppose C has signed it and just handed over it to D. So how D will convert it as a full endorsement? Yes, Sushri, very correct. By mentioning the name. So D will mention it. See, when D is holding that instrument, it's become a bearer instrument. He either just hand it over to anybody by mere delivery, right? And then the status of that instrument is a bearer instrument. But the moment he will mention the name of any person whom he want to pay or endorse, you can say, by mentioning the name of that person just above the signature of C, then it becomes a full endorsement. But what do you think? What is the role of D then in this case? Because D has just signed it over your D has. Do you think D has to sign it for endorsement in order to make it full endorsement? So see, you have mentioned that he will simply mention the name. Do you think he has to mention? He has to sign also? No, he need not require to sign it, because in case of bearer instrument, what is happening? It is just the hand is getting changed, but how many hands has been changed? Nobody has record of it, right? So instead of D would have handed over it to E, F, G, H. So all this person is not required to put their signature there. They just by mere delivery making the instrument transfer to other, and any person in between, in order to convert that blank endorsement to full endorsement, just mention the name of that person whom they want to make the payment done, right? So just above the signature of C, they will mention the name, and no need to mention their no need to have us put their signature, and just नाम लिख लिया आपने, और फिर ये कन्वर्ट हो गया फुल इंडोर्समेंट में. बट जब हम फुल इंडोर्समेंट में कन्वर्ट कर रहे हैं, तो आपको क्या लग रहा है कि ये जो जितने बीच में इंटरमीडिएरीज आए, मान लीजिए डी ई एफ, ये जो तीन आए, उनका क्या रोल रहा? जब एफ सपोज जी ने आपका एच का नाम मेंशन किया, तो जितने भी हैं डी ई एफ जी, उनका क्या रोल रहा? कोई रोल नहीं रहा, राइट? मतलब उनकी कोई लाइबिलिटी नहीं आएगी। ऑन रिकॉर्ड क्या हो रहा है, सी के बाद एच के पास जा रहा है पेमेंट। इस बीच में अगर मान लीजिए ट्रांजेक्शन में कोई डिफेक्ट रहता या कुछ भी रहता, तो आपका डी ई एफ जी जितने हैं इनको कोई लाइबिलिटी नहीं आती। That's why it is always to be suggestible that it should be a full endorsement, because in that this way you will keep a no have a record of how many hands it has been changed. See, holder has no liability as he converting blank to full by mentioning the name of endorsee above the endorser's signature. This is what I was saying about. Okay, section 50. So the endorsement of a negotiable instrument followed by a delivery transfer to the endorsee, the property therein with the right of further negotiation, but the endorsement may, by express word, restrict or exclude such right, or may merely constitute the endorsee an agent to endorse the instrument or to receive its content for the endorser or for some other specified person. So this is basically, this entire definition is basically saying about a restrictive endorsement, wherein the person is restricting. Suppose A, uh, being a payee, has endorsed it to B. Okay, at the time of endorsement, he mentioned he is restricting that this amount is only received by B. In that case, B cannot further endorse it. So this whole definition is just saying that only. Okay, let's see the illustration. B signed the following endorsements on different negotiable instruments payable to bearer. Pay the contents to C only. So when we have seen that this word only, it means that this instrument is only this the instrument carrying the amount is only received by C, and he cannot further endorse it to anybody else. Pay C for my use. So here also it is saying that only C has going to receive that amount and nobody else. Okay. Pay C or order for the accounts of B. See, here it is saying that or order for the account of B. If it is mentioned that pay C or order or to his order. So if it is mentioned that or to his order, that means C has further right to no endorse it. But here it is mentioned that order for the account of B means B can only endorse it, not C. So C has only right to receive the amount. Okay, the within must be credited to C. So it means that whatever the amount the negotiable instrument is carrying, that must be credited to C, and C cannot endorse it further. These endorsement exclude the right of further negotiation by C. Obviously, it cannot be transferred further. But if the endorsement says pay C, so that means C has right to endorse it further. The endorsement can be mentioned in a two manner. Okay, either it will mention only a specified person name, or it can mention a specified person name or to his order. So when it is saying to his order, means that specified person has right to endorse it further. Pay C value in account with the Oriental Bank. So it is just saying the amount. It is further transferable. Pay the contents to C being a part of the consideration in a certain deed of assignment executed by C to the endorsers and others. This is also further endorsed. Any queries? Okay. Section 56 says about your endorsement for part of sum due. See, if any endorsement is saying that suppose an instrument is carrying your 1,000 rupees value, but the pay is only endorsing your 500 rupees and not the rest of the amount, that is not possible. Okay, that is an invalid endorsement, and only whenever the endorsement is done, it has to be done for the full amount, not the part amount. Okay. Section 52, it says about your two kind of endorsement. One is about conditional endorsement and another is about your contingent endorsement. So if you go through this definition, you will understand that that see, if I read it, okay, the endorser of a negotiable instrument may, by express words in the endorsement, exclude his own liability thereon. Okay, so exclude his own liability thereon means how an endorser will exclude his liability. What happened? Uh, why a endorser is looking for? Why this law itself came? Why endorser would like to reduce? Would like to exclude his liability? Endorser is not necessary to be a maker of the instrument, right? He just an holder of the instrument can be a possibility. So he might not be aware that this instrument, um, the person who has given this instrument, like maker of the instrument, that is a real maker or not. There might be a possibility that it is a fake instrument, also a possibility, right? So in order to avoid that scenario, any kind of liability, because if that instrument became dishonored, then whoever are the intermediaries may all will be liable for that. Correct. So this instrument is saying that endorsement is also possible wherein the holder can exclude his own liability. Okay, and whenever a person who is excluding his own liability, that is called as endorsement without recourse. Another is your make such liability of the right of the endorser to receive the amount due thereon depend upon the happening of a specified event. Means the endorsee will receive the amount only when certain specified event will happen. Okay, such event may or may not happen. In that case, what it is saying, that it is saying about contingency. The first is talking about your conditional, and other is your contingency. So this section is providing you two type of endorsement. Okay. Now, illustration is your the endorser of a negotiable instrument sign his name adding the word without recourse. So when he mentioned no, when he mentioned without recourse, that means he is not liable if that instrument dishonored. Okay, and okay, if I say that, is it a possible scenario wherein a maker uh, becoming a holder, when the holder maker being a holder endorses the instrument further, can he also mention it as without recourse? Is it a possibility? Okay, please read this example. Okay, A is the payee and holder of a negotiable instrument. Excluding personal liability by an endorsement without recourse, he transfers the instrument to B, and B endorses it to C, who endorses it to A. A is not only reinstated his former right, but has the right of endorsee against B and C. See, A has endorsed that instrument, but at the time of endorsing, he is mentioning without recourse. But the further endorsement, whenever happen, they have not chosen this right. So A uh, now has right, if from whomever he has received that instrument has not made the payment, then he can take action against B and C. Is it clear?
And can you repeat it again?
See, what is happening in this scenario? Suppose Mr. X, being a maker of the instrument, has given this instrument to Mr. A. Okay, A being the payee, he has endorsed this instrument without recourse to B, and B further endorse it to C. Now, B, while endorsing it to C, he has not chosen the right of without recourse. Without recourse means B is now, since he has not chosen, means he owes that liability. Okay, if the instrument has if the instrument is going to be dishonored, then B is also being liable because he has not mentioned without recourse. Now B has further endorsed it to C. C has further endorsed it to A. A now has two right. Now he is paying as well as holder of the negotiable instrument. But as a payee, he has not. He has excluded his right. He has excluded his liability. So he has right if that instrument no dishonored. So if Mr. X dishonored this instrument, will not make the payment, then Mr. A has right to take action against Mr. X as well as against Mr. B and C. Is it clear? But B and C cannot take action against A because B and C also can go na that B has received this amount from this instrument from A, but since A has no mentioned it without recourse, so B and C cannot take action against A, but A
Ma'am, then
has
can
right.
more than one person take the like plea of recourse
Yes,
in
yes,
one transaction?
yes, they can do that. There is no such restriction, but it is again like it is again no, that other person has to accept that instrument. So when there is lot of intermediaries and everybody is choosing that, then might be that instrument is not the last person might not be accepting that, or the next person might not be accepting that. So it depends upon that, but there is no such restriction that no only a specified number person can use that without recourse right. So we have understood that three conditional, contingent, and without recourse. Now negotiation back. So in this, what is happening? The A is receiving that instrument. So in this, your this instrument is coming back to A. Correct. So when it is coming back to A, so that is called your taking up of bill, and A can further A can further endorse it, right? So from this from like see A B C and then again it comes to A. Now A can further recourse it, can further endorse it, but when A has to further endorse it, he has to cancel all the intermediaries which has there when it comes back to A. So he has to cancel B and C when A further want to no suppose A further want to uh, endorse it to me Priyanka, then in that case he has to cancel all the endorsement all the intermediaries before it received before he received that instrument, that is B and C. That is what called as taking up a bill. Okay. Without recourse, we have understood that if instrument dishonored, then no liability. Who is not liable? Person endorsing. To whom not liable? Endorsee or subsequent holder. This is the same thing that the person who has mentioned his no at the time of endorsement who is mentioning without recourse, that person will not be liable. And to whom he is not liable? To the subsequent no to whomever he has endorsed that instrument. So that is that other person whom he is endorsing that instrument is called as endorsee, or endorsee has further endorsed it, then it is called subsequent holder, right? So to all those person he will not be liable. So we have understood what is negotiable instrument. So if just by definition we understand that negotiable instrument should be your written. So any oral negotiable instrument, suppose if I say that I promise to pay you rupees 5,000 on certain date, so this oral declaration is not amounted to negotiable instrument. Any negotiable instrument has to be in a written manner, and it has to be signed by a person who is no who is making that instrument. And it the basic characteristic of any negotiable instrument is it is transferable. Otherwise, if it is not transferable, the whole objective of reading this negotiable instrument is not there, right? So the whole purpose of reading the negotiable or having the act of negotiable instrument or a negotiable instrument is that an instrument is transferable, title free from defect. So this is about this we will read it in a holder in due course properly. Okay, can be transferred from number of times, unconditional promise or order to pay. So the promise need to be unconditional, that it should not be dependent upon certain we have read about unconditional we have read about endorsement being conditional, but we are not saying about that negotiable instrument is conditional. So don't confuse with these two. Endorsement may be a conditional one, but a negotiable instrument must be unconditional. So there is unconditional promise to pay. I will not say that that Mr. A will not say that I will pay to Mr. B this amount only when B will marry. So there is a condition attached to make the payment, right? The first but uh, do you think if Mr. A will say that he will make the payment to B only when your uh, Mr. X will die? Again, it is a conditional promise to pay. So any kind of condition to pay is not should not be there in negotiable instrument. Okay, the promise or order to pay must consist of money only. So if Mr. A say that ki, okay, I will make you I promise to pay horse to you on this particular date, then this will not no this will not be a negotiable instrument. But he can mention that I will pay you 100 rupees at 12% interest per annum. In this is again this is a calculative no description of the money. So one person can easily calculate that on what date it has been issued, and what date it has to be make the payment is going to be received, and what is the rate of interest, and then on that the amount plus interest can be added. So it is again a money only. Okay, so that is a valid negotiable instrument. Certainty of sum payable, time of payment, and the pay. So all this should be certain. So how much amount you have to make the payment, that amount should be certain. You cannot say that a random, like this amount will be calculated on this date, and there is no such calculation meter is provided. So the amount is uncertain then. Okay, so time of payment has to be specified. It should be certain. And if it is mentioned that suppose on the date of X the amount will be paid, so again this is a valid one, because time of payment is certain only because death is certain. Okay, whom to make the payment, that pay should be certain. Okay, this we have already discussed why the word delivery is very much important. Okay, so tell me whether this instrument is a whether this money is a negotiable instrument, whether a money is a negotiable instrument. In the money you have, आप लोगों ने पैसे में देखा होगा ना, यहाँ पे लिखा हुआ है आई प्रॉमिस टू पे द बियरर द सम ऑफ रुपीज दिस. So what do you think? Money is a promissory. Money is a your negotiable instrument. Okay, Sadhna is saying no. Anybody else has different opinion? It also mentioned, na, I promise to pay to the bearer the sum of rupees this. Anusuya is saying yes. Money is a negotiable instrument. So can anybody tell me what? So basically, who is saying that money is your negotiable instrument? So Obviously they might be considering is a promissory note, right? So what do you think, that in the negotiable instrument section 13 they have mentioned only three? Why not they have mentioned money? Anusuya, do you think that money is a negotiable instrument but not regulated by money negotiable instrument act? Can anybody tell me what is money? In a lighter note, I just remember, I think my daughter is knocking door. I hope it is not disturbing you all. I think there is one song, Kya Cheez Hai Paisa. So, can anybody tell me what is money? We have understood ना negotiable instrument क्या है. पहले समझ लेते ना क्या मनी मनी क्या है. Then we will understand whether money is a negotiable
Ma'am, I
instrument.
think money is not a negotiable instrument as it creates a direct transaction.
It creates a direct transaction. वो तो negotiable instrument में भी हो रहा है ना. आप गए सामान लिए, आपने एक negotiable instrument दे
मैम
दिया.
इसमें कोई endorsement और लीगल डॉक्यूमेंट के थ्रू नहीं हो रहा है.
नेगोशिएबल
तो
इंस्ट्रूमेंट में भी आपको इंडोर्समेंट करने की जरूरत नहीं है ना. आप ब्लैंक रख सकते हैं ना, जैसे सेल्फ चेक आपने देखा ही होगा. नॉर्मल डे टू डे लाइफ में हम लोग बाकी इंस्ट्रूमेंट तो नहीं डील कर रहे होते हैं, बस चेक तो देख ही रहे होते हैं ना. आपने अपना बैंक का चेक बुक में चेक सेल्फ लिखा और बस आप किसी के हाथ में दे दिए. वो पर्सन बुक जितने भी लोगों को देना चाहे वो दे सकता है.
मैम इसमें तो राइटिंग और साइन भी नहीं है.
इसमें राइटिंग और साइन है ना. किसमें नहीं है देखिए. नोट में भी है, चेक में भी है. चेक में तो हाँ चलिए, चेक का तो अपने समझ रहे हैं. है ना, इसमें भी है आपका. यहाँ साइन है ना. और ये रिटन नोट ही तो है. और कोई.
मैम पर्सन जो पे करे उसका साइन होना चाहिए ना.
हम्म.
पर इसमें तो नहीं है मॉनी में.
एक्ट राइट दे रहा है ना कि आपका गवर्नर इज साइनिंग मींस दैट्स हाउ द स्टेट इज इशूइंग योर नोट, राइट. एवरीबडी हैज रिप्रेजेंटेटिव. अगर प्राइवेट लिमिटेड अगर आपका नेगोशिएबल इंस्ट्रूमेंट इशू कर रहा है और वहाँ पे डायरेक्टर अगर साइन कर रहा है नेगोशिएबल इंस्ट्रूमेंट को, तो यू विल नॉट सी ना दैट कि द कंपनी हैज नॉट साइंड इट, और देयर इज अ सिग्नेचर ऑफ डायरेक्टर इन द नेगोशिएबल इंस्ट्रूमेंट. Negotiable instrument, even the maker can be a company, right? और क्या सोच सकते हैं आप लोग. आप रीड कीजिए लोकल इस सेक्शन 1. ओके, लेट मी. सी, It extend to the whole of India, but nothing there herein content affect the Indian Paper Currency Act. Okay, so now it is RBI Act 1934. Okay, so RBI is only having an authority to issue currency, and negotiable instrument. So that's the reason that money will not come under Negotiable Instrument Act. Okay, nobody can issue that currency. It's only an RBI. It's only RBI or central government. Okay, and if you read that section 21, or affects any local uses relating to any instrument in an Oriental language. So this give you, this says about your hundi to any instrument in an Oriental language. So this no saving section is saying two things. One is uh, your money is not negotiable instrument, and another is your all these instrument which are in Oriental language, like your hundi. These are again this negotiable. It is though not regulated by Negotiable Instrument Act, but these are your negotiable instrument. Okay, so any instrument which are under issued under mercantile your custom or trade uses, that is getting validity through saving clause. Okay, and money here, though it is mentioned as Indian paper currency note, but it currency act, but now it is RBI Act 1934. Okay, I think what's our class ending time? Like, if all of you wanted to continue it further, or shall we end the class? Shall we continue, or we'll do it tomorrow? The rest of the part.
Then we can continue till 10.
Okay. Rest of you, if anybody has problem, then please drop me a message. I'll just accordingly take the majority of people decision. Okay. So I hope it is clear. And can anybody help me to understand what they understand from money? कुछ आइडिया है कि मनी का निजात कैसे हुआ, पहले कैसे सिस्टम था?
Previously, transaction was used to take place in the form of barter system.
करेक्ट. आपका बेसिकली डोमेस्टिकेशन और एग्रीकल्चर जब स्टार्ट हुआ, उस समय के बाद से ही आपका ट्रेड एंड कॉमर्स बढ़ने लगा, एंड देन थ्रू बार्टर सिस्टम इट वाज इनिशियली, एंड देन लेटर ऑन इट इज coins and your metal exchange of metal, and after that your money came into picture, wherein money is deriving value from the metal, your any precious metal like gold or silver. So it is basically your gold. सो उतनी ही आपकी मनी इशू होती थी जितनी आपकी गोल्ड है, राइट? So later on, when there is a further requirement of money, then the base is kept as your gold, and then the value of that is further, like suppose 1:1 के जगह पे अगर आपको ₹2 earlier no assign था, आपका £1 is equal to one your rupees of this, then in that case when for more amount of money has to be issued, then your value of the gold is getting increased. Then this is how it is creating a problem, because there is a limited number, there is a limited amount of gold. So later on, in I think in 1970s or 73, I think it has been abolished. The backing up of gold has been abolished, and in modern framework, we are seeing your fiat money, which is called a paper currency, which we are seeing that is backed by law. and not by gold. Correct? Okay. So let's study your promissory note. A promissory note is an instrument in writing, not being a banknote or a currency note. It further clarifies it. Okay, that promissory note is not your banknote or a currency note. Because in the in the note, your in currency note, we are seeing that a promise to pay to a bearer. So it says that it looks, it's what it gives a picture that it is a promissory note. But the promissory note, by no specifically by writing itself, by law, it is excluding that banknote or currency note is not a promissory note, because this is only issued by your RBI or your central government. Okay, so it is mentioned in your section 31 of RBI Act 1934, that a promissory note cannot be made payable to the bearer. Okay, so if it is saying this, because a money being a promissory note, like money is what is a promise to pay to a bearer, so that is your currency, right? So that is only issued by your RBI or a central government. Hence it is mentioned that promissory note cannot be made payable to a bearer. So in this definition we have to apply your section 31. A promissory note is an instrument in writing, not being a banknote or a currency note, containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. Now, you might confuse that. Na? Here it is mentioned or to the bearer of the instrument. Okay, so what it says that since we have to apply this no, section 31 of the Bank of India Act, it is not payable to a bearer, like it is not no transferable by mere delivery. It is transferable by endorsement and delivery. Okay, so the person who is holding that instrument can no, show that instrument to a maker and receive that amount. So endorsement and delivery is still possible, right? So there will be a number of person. So in this case what is happening, uh, that sum is not payable only to a certain person, but to a person who is but also to a person who is holding that instrument, whom that is endorsed by that specified person. I hope it is clear. Okay, I think you can read this example. This will further help you. Promissory note states that A promises to pay to B or to his order a sum of 10K. Now, thus money would be recoverable by B. If B endorses and delivers to C, then C, being a bearer of the instrument on the order of B, can recover the amount from A. This is how we have to know, again little under like applying section 31. If we have to read that definition, then we have to understand in this manner. Okay, A signs instrument in the following terms: I promise to pay B or order rupees 500. Do you think this is a valid promissory note? I promise to pay B or order rupees 500. See, B or order means B can further endorse it, and it is a valid promissory note because here it is mentioned that there is a no, certain person, and the amount is also certain, and uh, so it is a valid promissory note. I acknowledge myself to be indebted to B in rupees 1000 to be paid on demand for value received. So this is not a bearer instrument because the name of the person whom you have to make the payment, that person name is specified. Okay, so this is again a valid instrument. But here it is written that in C, Mr. B, I owe you rupees 1000. There is no promise to pay. See, if you apply the definition, unconditional undertaking signed by maker to pay a certain sum of money only to or to the order. So it has to be in the writing, and there is promise to pay a certain sum of money, right? But in this example, there is no promise to pay. He just say, see, he's just acknowledging the debt. There is no promise to pay that amount. So this is not a valid instrument. Again, I promise to pay B rupees 500 and all other sums which shall be due to him. So they if it is mentioned here 500 and all other sums, so all other sum, what it indicates, there is no certain sum of money, right? So again, this is not your no valid promissory note, because the amount should be certain. Again, e number, I promise to pay B rupees 500, first deducting thereout any money which he may owe me. Again, this is again making it not a certain sum of money, because we don't know that how much amount has to be deducted, right? I promise to pay B rupees 500 7 days after my marriage with C. So it is not your unconditional undertaking to pay. There is a condition attached, right? After my marriage with C. So, and also whether he will marry or not, who knows? Whether before the marriage date he will die. So there is no certainty of date also. I promise to pay B rupees 500 on D's death, provided D leaves me enough to pay that sum. So if it is written only on D's death, then it is fine, because death is certain thing. But provided D leaves me enough to pay that sum, it is again unconditional. It is not an unconditional undertaking, right? There is a condition attached. So this is again not a valid promissory note. I promise to pay B rupees 500 and to deliver to him my black horse on 1st January next. It is again not a unconditional undertaking. So from this definition, we understand that it should be in writing. The express promise to pay, the promise to pay should be there. Okay, only an acknowledgement of debt will not be enough. It should be definite and unconditional promise, signed by maker, promise to pay money only. So if it is mentioned that I will pay you certain goods or certain amount of kg of rice, so that will not be your promissory note. Promise to pay a certain sum, so amount should be certain. It and or it is calculated in a certain manner. So if I say that 500 plus 12% of interest, then it is also again a certain sum of money. But whatever the example which we have read, that is not giving a certainty. Pay must be certain and stamped. I hope everything is very simple. And if anybody has queries, please we'll take a query, and then we can end our class today. Because next topic will be bill of exchange. So bill of exchange, we will take it in our next class, and then we will understand what is the difference between bill of exchange and promissory note, and check, truncated check, electronic check. All these things we will understand in our next class, and other residual part. Is there anybody having any queries? Yes, Anusua.
Ma'am, if we want to put any condition in promissory note while transaction, how we can put the condition and how it can be endorsed in a valid manner?
So the undertaking, promise has to be unconditional. You cannot put condition in that.
Okay.
Endorsement, you can endorsement, there can be a condition attached, but not on the because promissory note is your negotiable instrument. So in negotiable instrument, it should be under unconditional undertaking, the and any of this instrument, because negotiable is when we are saying unconditional and unconditional no promise, or the instrument, negotiable instrument should have should have no condition attached. That means whether it is a promissory note or bill of exchange or check, that it should be unconditional only. But in case of your endorsement, you have the right of no attaching any condition or contingency.
So, ma'am, while endorsement, we can put the conditions.
Yes. You can say
Okay,
that
ma'am.
this amount will be payable to you, matlab, like not for the negotiable instrument, but this amount will be paid to you only when you become major. That at the time of endorsement that can be put.
Okay, ma'am. Got it.
Yes, anybody else? So we'll end our class today. Okay, thank you all, good night.
Thank you, ma'am.